What I have for you today is not one, but two cases about exchange of information and taxpayers trying to stop that exchange from information. And one case is from the Federal Court of Appeal in Canada, and the second case dealing with the same exchange of information is from the Bundesverwaltungsgericht in Switzerland. Canada requested information from Switzerland, and the taxpayers tried both in Canada and in Switzerland to quash this exchange of information. Now to tell you a little bit more about what's going on, you need to know the background of this. You can see here a picture of a guy called Levett Baazov, accused of insider trading. You can see mention here of Panama Papers, and you can see the Panama Papers reports, and they're typical, showing who's connected to who with a company called Zappa Holdings. And the background to this is Mr. Baazov and his partner were mentioned in the Panama Papers. They were, at least Mr. Baazov, as far as I know, prosecuted for insider trading. I don't know what the outcome of that decision was. And the Canadian tax authorities did pick up on this through, among others, the Panama Papers. I think it is interesting because, spoiler alert, the taxpayer lost completely in front of both courts here. But what we don't know is whether the taxpayer lost because of the pure arguments brought forward, which would be the theoretical ideal, but not the human story, or whether part of the reason why they lost was because it involved the Panama Papers, because it involved online gambling websites, maybe even because it involved a Russian citizen. I don't know. But let's talk about the case and what a 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. I don't think the court's decision was wrong. Let me be very clear. I think it is right and it's fair, and I think a lot of the arguments were very formalistic. But so here we go. Let's see what they discussed. The Court of Appeal in Canada, we look at the Canadian decision first, says before us, the appellants contended that the request for information, or the RFIs, ought to have been squashed on the basis that the Canadian Revenue Authority, and then says ought to have been squashed because these were already in the lower court, the taxpayers' requests were denied, so now we're in the Court of Appeal. And they say, one, the CRA did not exhaust all domestic avenues to obtain information sought, so they shouldn't have gone for exchange of information. They should have done their own homework first. Two, the RFIs were based on false allegations. Three, he did not provide full and frank disclosure to the Swiss authorities. And here the issue was the taxpayers were ordered for 2010 or to 2013, but they asked for information from 2010 to 2015. But the court, the Swiss authorities and the courts were aware of this, and we'll see that later. 4, they illegally sought and obtained solicitor client, and I guess this is attorney-client privilege information. And 5, they illegally disclosed confidential taxpayer information. So these were the complaints why the exchange of information should be stopped. And then let's just look at the Canadian-Swiss treaty and see what Article 26, normally under the Moral Convention, but now 25, says. It says, the competent authorities of the contracting state shall exchange such information as is foreseeably relevant, right? And then it's pretty much the normal OECD text. But the Swiss-Canadian treaty is an interesting one because it has a protocol amending the treaty. It is an old treaty, so you can see already here the treaty was from 1997, the protocol was from 2010, if I remember correctly. And the protocol changes in Article 10 and Article 25 and a number of other articles. And then the protocol has a protocol about the interpretation of the treaty. The protocol literally has an interpretive protocol as its last article. And it says, the Government of Canada and Swiss Federal Council have agreed at the signing of the protocol amending the convention at Bern 1997 on the following provisions which shall form an integral part of the convention, right? And then you can see here they amend Article 25, or they interpret Article 25, and they say it is understood that an exchange of information will only be requested once the requesting contracting state has pursued all reasonable means available under its internal taxation procedure to obtain information. So the taxpayer's first complaint, the Canadian revenue authorities have not done that, right? And then 2, it is understood that the competent authority of the requesting state shall provide the following information, and then it gives a list here that you see from 1 to 5. And then part of the taxpayer's complaint at some point is that the Canadian revenue authorities gave more to the Swiss than is in 1 to 5, and that is how they gave excess private information to the Swiss authorities, which they found to be a problem. And then letter C, and now we come to purpose and intent of the treaty. It says, it is understood that the standard of foreseeably relevance is intended to provide for exchange of information in tax matters to the widest possible extent, and at the same time to clarify that contracting states are not at liberty to engage in fishing expeditions. So on the one hand, you can't just ask enough questions and hope that one of the answers will be useful. On the other hand, you can exchange information as widely as possible, right? So clearly the question here becomes, what does it mean, A, foreseeable relevance, and B, that you need to have pursued all reasonable means available under internal legislation, right? And then not only do you have a protocol with an interpretive protocol, but then afterwards there was also an agreement concerning the exchange of information. And basically what it talked about is that, in paragraph 2 of the interpretive protocol, letters B1 through 5, we might not always have everything that's asked for in 1 and 5. But even if we don't, then that's not going to be an excuse for not exchanging information, right? So this is a letter which comes from the Swiss authorities to the Canadian minister. You can see is the Honorable John Baird, Minister of Foreign Affairs in Canada, whom it's addressed to, and then the Honorable John Baird then responds also to his Swiss counterpart. And he says, I have the honor of confirming the receipt of your letter of 28 June in the English and French languages, reading as follows. And he repeats the whole letter on how to interpret this paragraph 2 regarding points 1 and 5, and that they won't always be needed in full. And it says, it repeats up paragraph C again of paragraph 2 of the interpretive protocol, clarifies that while these are important procedural requirements that are intended to ensure the fishing expeditions do not occur, these requirements nevertheless are to be interpreted in order to not frustrate the exchange of information. So clearly we want to exchange information, right? You can see that in the highlighted text here. And then it ends this letter saying, I have the honor of confirming on behalf of the Government of Canada that the proposal of the above-mentioned letter is acceptable to the Government of Canada. Therefore, your letter, together with this reply, the English and French versions of each letter being equally authentic, shall constitute an agreement between our governments and shall enter into force on the date of the second note, etc., right? So this is a very interesting example when we come to interpretation of treaties and the Vienna Convention on the Law of Treaties, which says, that you can conclude a treaty and you can subsequently agree between the two states on how to interpret the treaty, and here you actually have a letter which the countries agree becomes a separate agreement, which interpret not only the agreement but the interpretive protocol on the agreement, right? Included in the protocol on the agreement. It is quite an interesting combination of text. Now let's see what the Canadian Court of Appeal says with regard to exhausting domestic avenues before the exchange of information, right? And it says, the appellant correctly pointed out that paragraph 2b of the Convention's interpretive protocol required the CRA to resort to an exchange of information only once it pursued all reasonable means available under its internal taxation procedure to obtain information. But then the court says, however, as the federal court quite rightly noted, the CRA is under no obligation to pursue all available domestic means, right? So it only needs to pursue the reasonably available ones to obtain information, only all reasonable ones. Okay, the key to this obligation is the word reasonable. The language strongly suggests some measure of discretion in determining in any given case what you're going to pursue and what not, right? And then the court goes on to say, with respect to the exchange of information, the record shows that the CRA received information from a partner country. Very interesting. It doesn't say more about this, but apparently there's been some spontaneous exchange of information or something like that from a country which was not Switzerland. And CRA gathered information from online discussion forums, also very interesting, and I guess a lot of this was around the Panama Papers, that led it to believe that Messrs. Levett and Baazov, so Levett was a partner of Baazov, might have failed to report foreign investments and foreign income for 2011 through 2013. On June 30, 2015, as part of an audit undertaken by the CRA, questionnaires were sent to Messrs. Levett and Baazov regarding whether they owned residence property, bank accounts, or investments outside Canada, right? In response to these questionnaires, Messrs. Levett and Baazov denied having any foreign interests. In March 2016, the CRA, in charge of the audit, and the auditor, proceeded to interview Messrs. Levett and Baazov, and again, both denied any such interest. So they've been asked twice, do you have any offshore interest? And they've said twice, no, we don't, okay? The auditor's interview notes show that Mr. Baazov was confronted with confirmation linking him to Zappa Holdings, that's a company that we saw in the previous slide. However, he denied ever having been involved in the activities of this corporation. With respect to Mr. Levett, he was asked about possible links with Zappa Holdings and Killworthy Limited. That was another company listed in the Panama Papers. He responded not knowing anything about Killworthy Limited and not being involved in Zappa Holdings. And the auditor then explained, this was a woman, that she was not in a position to seek a court order under Article 231(7) of the Canadian law because Messrs. Levett and Baazov has responded to her request. They gave her information, so she couldn't pursue the same article again because they already gave answer, and because she did not have sufficient information that could contradict their responses. She explained the information she was looking for concerned foreign entities, right? These were not Canadian entities, Upper Holdings and Killworthy Limited. They were tax haven entities, and therefore she could not get further information. The auditor decided to proceed with the Levett Baazov request for information after she became aware of a publicly available decision on Quebec's Tribunal Administratif des Marchés Financiers dated 6 April 2017, and this was the insider trading decision, right? And this nourished her belief that Messrs. Levett and Baazov might have foreign interest, as that decision spoke of possible links with Killworthy Limited and Optivilla Holding, a third company. She further explained that the RFIs were unconnected to the audits performed on the Messrs. Levett and Baazov spouses because they too were covered by RFIs, which were related to the sale of shares to foreign companies, to a foreign corporation. So again, the third-party companies involved, and added that the wives' name appeared on the Levett Baazov request for information only in case Mr. Levett and Baazov had used their wives as nominees for their offshore assets, right? So it was just in case. The appellant claims that the CRA did not do enough in pursuing domestic means of obtaining the information sought on the RFIs. And then the judge says, I disagree. I am satisfied that it was reasonably open to the CRA in the circumstances of the case to proceed with the exchange of information at the time that it did it, in view of the fact that Messrs. Levett and Baazov had denied on more than one occasion having any such assets. And then the scathing sentence from the court. One wonders how many times the CRA need to be told by Messrs. Levett and Baazov that they do not have such assets before the CRA is allowed to ask for an exchange of information. Here already the court clearly shows that Messrs. Baazov and Levett are not their favorites, right? And then it goes on and it says, now what does it mean, this pursued all reasonable means available, right? And the court starts by looking at the text of the convention, and then it goes to the OECD commentaries. It says, when the language of Article 25 of the Tax Convention is read in the light of extrinsic materials, and then it specifically says the Model Convention's commentary on Article 26, it becomes clear that the true intentions of parties to that agreement was to promote the exchange of information to the maximum extent possible, not to limit it. So contrary to what the taxpayer is saying, they do want to exchange information, right? It is also important to underscore that the OECD countries have long recognized the need to improve administrative cooperation in tax matters, notably through the exchange of information and assistance in collection of taxes for the purpose of preventing tax evasion and tax avoidance. And this comes from the introduction of the OECD Model Convention. And then it goes back to this interpretive protocol. It says the true intentions of the parties are reflected, in my view, in the actual language of the provision of Article 25, coupled with the interpretive protocol. And now you go beyond the normal discussion of what the status of the OECD commentaries are because it's not part of the treaty, etc., etc. Here it is very much part of the treaty because it is part of the interpretive protocol, right? And the judge highlights a text also. It says the information which may be subject to an exchange of information only need to be foreseeably relevant, right? It must not be absolutely relevant. B, the notion of foreseeable relevance is intended to provide for the exchange of information in tax matters to the widest possible extent. And then C, the procedural requirements set on Article 2B of the interpretive protocol are to be interpreted in order not to frustrate effective exchange of information. Okay, so